We are on live. Good, Chandra. Good evening to all of you. Today we have finished up to section 25. Today we go to section 26. Section 26 says goods remain at the seller's risk till the property is delivered, but when delivered, it is with the buyer whether delivery is made or not. Here, when the goods still remain in possession of the seller and the seller does not part with the possession of the goods, it does not reach the buyer, then as far as the damage, destruction or deterioration is concerned, the seller is responsible and the risk is with him. But if the property has already passed or the seller has handed over the goods to a mercantile agent for being carried and delivered to the buyer, then the buyer is deemed to have come into possession of the goods and whether the delivery is made or not or whether it takes time. So to recap again or to repeat again, section 26 says goods remain at the seller's risk till the property is delivered, but when delivered, it is a buyer to whom delivery is made is responsible. So the thin line which separates the risk factor is when the position when the delivery is made. Suppose, let us say, the goods are not yet delivered, but the seller is in possession of the goods. It has not reached the buyer, but the seller hands it over to a mercantile agent or a carrier for being carried and delivered to the buyer. Then the risk passes on to the buyer. Are you able to understand, please? To be on the safe side, the seller should inform the buyer, I have already put the goods into transmission. You are responsible when it is delivered, and any risk, any damage, any deterioration, the buyer becomes responsible. But so long as the seller is in possession of the goods, they are not put in transit. They are not handed over to a mercantile agent. In case of damage, deterioration, etc., the seller is responsible. But once the goods are handed over to a mercantile agent, a carrier, for being transmitted or delivered to the buyer, then the risk passes on to the buyer whether delivery reaches him or not. Are you able to understand, please? This is what section 27 says. Then we go to section 27. This is based on the maxim, nemo dat quod non habet. What do you mean by nemo dat quod non habet? No man can pass a better title than what he himself has. In case a seller has no title, the goods belong to some other person and he has no documents of title pertaining to the goods, then in that case, even if the purchaser purchases the property, he does not get title to the property. This is what section 27 says. Are you able to understand, please? Then we go to section 28. Section 28 is joint owners. Suppose the property, the goods belong to brothers who are running a business as a firm, and one of the partners, let us say A, comes into possession of the goods, and then with the permission of the other co-owners, the property passes to the buyer who acts in good faith. So suppose it's the incidence of partnerships are every partner is an agent of the other, every partner is a trustee of the other, every partner is a manager of the other, and every partner has got the implied authority of parting with goods or dealing with goods. Suppose, let us say, the goods belong to three people who are running a partnership firm, and one of the partners, with the permission of the other co-owners, comes into possession of the goods, and he has got the authority to sell the goods. Then he enters into a contract with the buyer and supplies the goods to the buyer. Then the buyer, who acts in good faith and without notice that the person who delivers the goods or who is the seller is only one of the partners. But here one important criteria is that one co-owner who delivers the goods must have the implied authority or permission of the other co-owners to part with the goods. This is what section 28 says. So section 28 deals with a scenario where one of the property the goods belong to the co-owners. There are three people, let us say, constituting a partnership firm. and one of the co-owners, with the permission of the other co-owners, comes into possession of the goods. He has got implied authority to sell the goods. He has got implied power to sell the goods. He enters into a contract with the purchaser, delivers the goods, and then in that case, the purchaser, who acts in good faith, makes all inquiries possible without notice that the person who is transmitting the goods or delivering the goods is the proper person. So, in other words, the buyer gets a good title. Are you able to understand, please? Again, I repeat this section 28. It says, where the goods belong to joint owners who are running a business in partnership, and one of the co-owner, with the permission of the other co-owners, has got the power to deliver the goods or sell the goods, and he transmits the goods to the buyer for purchase, and the buyer acts in good faith and without notice, then in that case, the title of the buyer is protected. This is what section 28 says. It is not necessary that all the joint owners should join in delivering the goods. One of the co-owner who has got the consent of the other co-owners to sell the goods to a particular buyer, and he has got the authority to transmit the goods and sell it in a deliverable condition to a buyer, and the buyer who purchases those particular goods in good faith and without notice, the buyer is protected. This is what section 28 says. These are all small sections, please, because it consists of nearly Sale of Goods Act consists of nearly 62 sections. So the question is, you should not tell me that you have not dealt with this section or that section. That is the reason why I am going section wise. And please remember, the entire Sale of Goods Act, if you just look at it, it is completely dependent on conditions and warranties only. Right from beginning, it is only conditions and warranties. That's what the Sale of Goods Act says. Then 29 is where the seller has obtained possession under a voidable contract under section 19 of the Contract Act, but not rescinded, the buyer acquires title when he acts in good faith and without notice. Then again, I think yesterday I discussed, and we had a thorough discussion with Mr. Murligar also. As far as voidable contract is concerned, it should be rescinded at the earliest. But if time is allowed to lapse, then seller obtains possession under that voidable contract, let us say undue influence or fraud or whatever it is. But it is not rescinded. Not rescinded means not avoided. Then in that particular case, if he transmits the goods to the buyer, even though the seller has no title, but the buyer acquires title to the property if he acts in good faith and without notice. This is what section 29 says. These are all small sections, please. Then we go to section 30, where a person having sold goods continues in possession of the documents and the delivery or transfer by that person to a mercantile agent, the person receives them in good faith and without notice gets good title. Where a person having sold goods continues to be in possession of the documents, the delivery or transfer by that person or mercantile agent, and the person receives them in good faith and without notice gets good title. That is, suppose let us say goods are sold by the seller and he is in possession of not only the goods but also the documents which support his title. Then he transfers it to a purchaser and or puts it in transmission for being delivered either by himself or by a mercantile agent, and the mercantile agent goes and delivers the goods at the doorstep of the purchaser, and the purchaser makes all inquiries possible, acts in good faith without any malafide, and he has no notice of the earlier how the seller has come into possession of it. Then the purchaser, irrespective of the fact that the seller has a defective title, gets good title to the property. This is what section 30 is. Any doubts about it, please? Again, I repeat, where a person sells goods and continues to be in possession of the documents, the delivery or transfer by that person or mercantile agent to the purchaser, the person who receives them in good faith and without notice gets good title. Sir, please remember, sir, no one is a fool to keep the documents of title with a third person. That means the third person who has come into possession of the goods or the documents of title has come into possession or as the documents in good faith, and that he has got the goods in some way and he has got a marketable title, and he has got the authority to sell. But when he puts it in transmission to be delivered to the buyer, either by himself or by a mercantile agent, and the buyer to whom the goods are delivered acts in good faith and without notice, then in that case, the buyer gets a good title. This is what Section 30 says. Then 31 is a corollary to Section 30, sir. It says, duties of the seller to deliver the goods and of the buyer to accept and pay them in accordance with the terms and conditions of the sale, and the buyer shall be ready and willing. Like specific performance, it is said the buyer, not only the seller, but also the buyer. What are the terms of the contract, sir? The seller shall sell the good, deliver the goods, and the buyer shall accept it. You know, under the law of contracts, offer plus acceptance is equal to an agreement, and that agreement which is enforceable in a court of law, the agreement which is enforceable in a court of law or which is capable of being enforced in court is what is called a contract. And also, you know that every contract is an agreement, but every agreement is not a contract. I think there's a basic thing as far as law of contracts are concerned. Here, one of the duties of the seller is to deliver the goods. What is the duty of the purchaser, sir? When the goods are delivered, the purchaser has to pay the money. Delivery and what is called payment are contemporaneous unless otherwise provided. And then delivery and payment are contemporaneous. Who is going to deliver, sir? The seller is going to deliver. Who is going to accept the delivery? Who is going to accept the delivery? It is a purchaser. So offer plus acceptance is equal to an agreement. And that agreement which is enforceable in a court of law or capable of legal enforcement is called a contract. And the person who sells it should be ready and willing to deliver it. The person who receives and accepts the delivery should be ready to pay. So both are contemporaneous. Delivery as well as purchase are contemporaneous, but what is important is readiness and willingness. That is, once the goods are sought to be delivered, it has to be accepted by the purchaser. That alone fulfills the contract. Are you able to understand, please? The elementary position of the law of contracts is offer plus acceptance is equal to a contract, is equal to an agreement. And that agreement which is enforceable in a court of law is called a contract. That is why it is said every contract is an agreement, but every agreement is not a contract. For example, I say that I invite you for a cup of tea in my house or a breakfast. It's a social agreement because we are so. That's why Darwin says a human being is the best mammal ever created by God. We live in the society, we die in the society, we mix in the society, and we mingle in the society. And we have social obligations, and we also have social contacts with each other. We cannot say, I want to remain away from the society because we belong to the society and we also owe certain duties to the society. That is the reason, sir. Once offer plus acceptance is there, offer to sell, acceptance to take delivery, it completes an agreement. And that agreement, which is enforceable in a court of law, is called a contract. Suppose it's a social agreement. I invite you for lunch or I invite you for a breakfast. Due to some unforeseen reasons, let us say the tea party which I proposed to give it to you, or the breakfast which I have offered, or the lunch which I have offered is cancelled because of unavoidable circumstances. You cannot sue me in a court by saying, sir, because you told me that you will offer breakfast or you will offer lunch, I told my wife not to prepare food. That is not an agreement. If that is going to be enforced, what would happen is none of us will invite anyone for a breakfast or none of us will invite anyone for a lunch. These are all social obligations, sir. But those contracts which the parties desire that they should be attended to by legal consequences, only those agreements are contracts. This is a basic fundamental principle as far as law of contracts is concerned. That is why it is said every contract is an agreement, but every agreement is not a contract. But here, as far as this section 31 is concerned, the duty of the seller is to deliver. The duty of the seller is to deliver the goods, either by himself or to a mercantile agent. But as far as the duty of a purchaser is concerned, when the goods are delivered, it is his duty to be ready and willing to pay the price and take delivery of the goods. So both are contemporaneous, both are simultaneous. Delivery and acceptance are contemporaneous. They go together. Mr. Swami, you are able to follow, sir? Don't attach much.
He's disturbing the class.
No, he is not doing anything. Then sir, are you able to understand, sir? Delivery and payment of the price are contemporaneous. There should be readiness and willingness on the part of the seller to deliver the goods, and there must be readiness and willingness on the part of the purchaser to take delivery of goods and pay the price when the goods are delivered. So readiness and willingness is not only for one person, it is also for the seller and it is also for the purchaser. Are you able to understand, please? That is delivery on payment of price. So both go simultaneously. No question of isolating one from the other. That's why it is said that in the law of contracts there is a quotation to say an acceptance is to an offer. Please again I repeat, an acceptance is to an offer what a lighted match is to a train of gunpowder. What do you mean by that? Suppose, let us say you have a tree of gunpowder. You know what gunpowder is, which is used in pistols and which are used in guns. And so long as the gunpowder remains on the table without being ignited, it remains to be a gunpowder. But once you take a match and light it, there's a big explosion that takes place, and you cannot even retrieve a single particle of gunpowder. So that means once an offer is made and it is accepted by the other side, and it's accepted, then offer plus acceptance is equal to an agreement, and that agreement, which is enforceable in a court of law, is what is called a contract. So first and foremost you must remember is readiness and willingness. Readiness and willingness, both on the part of the seller to sell and on the part of the purchaser to pay for the delivery and the price thereof. Are you able to understand, please? So wherever possible, I'm trying to connect it with contracts so that you understand it properly. Then we go to section 32. Section 32 says, unless otherwise provided, delivery of the goods and payment of the price are concurrent, the seller shall be ready and willing to give possession of the goods to the buyer in exchange for the price, and the buyer shall be ready and willing to pay the price in exchange of the goods, exchange of the possession. See, after all, in a sale, what takes place, sir? Suppose you are there, one of you is there. Suppose you have a motor car. Then let us say you want to sell the motor car. I want to purchase your motor car because I'm very much interested in buying it. You offer your motor car for sale. Naturally, you don't offer it for a song. You quote a particular price. Both of us agree for a particular price, and then you deliver possession of that motor car to me, and immediately I pay you the consideration. Whatever consideration is agreed upon, I pay to you. That means on delivery, on taking possession, it is my duty as a purchaser to pay the consideration. In other words, readiness and willingness to deliver possession should be there as far as the seller is concerned, and as far as the purchaser is concerned, readiness and willingness to pay the price of the consideration, both are concurrent, both take place simultaneously. Are you able to understand, please? So one does not, it is something like husband and wife. At all times they don't leave each other. So the question is, when I want to enjoy property, when I have to acquire something, I'll also have to pay the price. The seller parts with possession, he gets the consideration by way of the sale price. As far as the purchaser is concerned, he gets the possession, but whatever is the cost, he has to pay. And the readiness and willingness should be on the part of the offerer, that is the seller, and the acceptance should be also on the part of the purchaser, and the purchaser should be ready and willing to pay the price as and when the goods are delivered to him. This is what section 32 says. Then 33, delivery of goods sold may be made by doing anything which the parties agree shall be treated as delivery, or which has the effect of putting the goods in possession of the buyer, or by any person authorized to hold them on his behalf. Here, The seller has already parted with the goods. He has handed it over to the carrier, or he has handed it over to a mercantile agent. Informs the buyer, sir, I have put the goods in a deliverable condition. Please accept delivery of the goods. And then what it says is immediately it is not delivered, but it is delivered through a mercantile agent or an intermediary, and intimation is also given to the purchaser, sir. It is put in a deliverable condition. I have handed it over to a mercantile agent. The mercantile agent will deliver it to you. Then, in that case, it is said it has the effect of putting the goods in the possession of the buyer or of any person authorized to hold them on his behalf. So, what is the duty of the seller, sir? Seller intimates the buyer, I have kept the goods ready. I have put it in a deliverable condition. I have put it in transit. I have handed it over to a carrier. I have handed it over to a mercantile agent. It will be delivered to you on so and so date. And what the purchaser should do is he must accept delivery of the goods, and then either it is delivered to the purchaser or to his agent or manager who is controlling the business. This is what Section 33 deals with. Shall I repeat this section again, please? Where delivery of goods, how the delivery of goods may be done by doing anything which the parties agree shall be treated as delivery. See, please don't expect that the person sitting in Rajamandri is going to come all the way to Hyderabad in the lorry and deliver the goods to you. No, no person does it. What he does it is he hands it over to a carrier, lorry transport, or a railway, or some other mode, let us say. Then he also intimates the buyer, sir, I have put the goods in transit. I have handed it over to so and so agent or a lorry transport. I am also sending the documents to you. Please accept the goods on delivery. So the goods, when it arrives at the appointed place, it can be delivered to the purchaser or to an agent of the purchaser or any other person is authorized to take delivery. This is what Section 33 says. Then we go to 34, sir. A delivery of part of goods in progress of the delivery of the whole has the same effect for the purpose of passing the property as a delivery of the part, which part delivery of the goods with an intention of severing it or on the whole does not operate as delivery of the remainder. Suppose, let us say, sir, you can't expect the seller should have possession of the entire bulk. Suppose I order for 10,000 bags of rice. The seller does not have the 10,000 bags of rice. He says, sir, I'll supply to you within a period of 6 months in 3 installments. Every 2 months, I shall supply you for 5,000, 3,000, 3,000, 3,000, 1,000, like that in installments. Suppose, let us say, he delivers part of the goods. Like the first consignment he sends, he delivers about 3,000 bags. Does it mean he is absolved from the liability from delivering the remaining 7,000? No. Part delivery operates as part satisfaction of the contract to sell the entire bulk. And in the first installment, 3,000 bags are sent. Second installment, 3,000 has to be sent. Third installment, 3,000 has to be sent. Fourth installment, 1,000 has to be sent. Just because I've sent you part of the goods which is ordered or which is booked, it doesn't mean it absolves the seller from supplying the remaining bulk. So it does not operate as what is called being relieved of delivering that 7,000 bags. Till those 7,000 bags are delivered in installments, the seller is bound to supply the goods at the appointed time. Are you able to understand, please? If the goods are agreed to be delivered in installments, not immediately, according to the terms of the contract, suppose I agree to deliver it in 5 installments of 10,000 bags. First, I send you 2,000. After a month, I send you 2,000. Next month, 2,000, like that, to make up that 10,000 bags. But delivering only 2,000 bags in the first installment does not absolve the seller from his liability to perform the rest of the obligations in installments. This is what Section 34 says. Are you able to understand? Please remember, after all, you must have a flexible attitude when you are a purchaser or when you are a seller. You cannot have hard and fast rule that all the goods have to be delivered at the same time. It is not possible, sir. Why? Because of so many conditions. We are facing drought, we are facing famine, we are facing floods, we are facing tsunami. the hurricane, so on and so forth. Sometimes what happens is the goods which are agreed to be delivered gets washed away by floods. Please remember, poor seller cannot do anything. That is the reason, sir. He says, I shall supply to in installments. But supplying one installment does not exonerate or absolve the seller from supplying the remaining goods or the remaining installment. This is what Section 34 leads to. Excuse me. Sir. 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 I think that also is expected. No. I'll stop with 40. Not 40. 40 and 46. 24, 26. Yeah, time might be 7:45. One announcement I would like to make, sir, that in Hyderabad we are having heavy rains, and anytime the current may go. But I'll try to cover as far as possible till section 40, and then stop, and then we'll have the interaction period, please. We go to section 35. It says the buyer is deemed to have accepted the goods when he intimates the seller that he has accepted the goods delivered and does any act or relation to that which is inconsistent with the ownership of the seller, or when after lapse of a reasonable time he redeems, uh, he retains the goods. Here, suppose the buyer informs the seller, sir, I have already accepted the goods. Thank you very much for the delivery. And that he says that he does any act. Suppose, let us say, goods which are delivered, he does any act which is inconsistent with the contract by utilizing it for his business, selling it in the market, making money over it, and and he waits for a reasonable time. Then without returning them, it is deemed that delivery has been made, purchase money has been paid, and the buyer or the seller cannot go back on the contract. This is what section 35 says. Again, I read the section, sir. The buyer is deemed to have accepted the goods when he intimates the seller that he has accepted the goods delivered and does any act in relation to them that inconsistent with the ownership of the seller, or even after lapse of reasonable time, he retains the goods. Please remember, when the purchaser informs the seller, sir, I've accepted the delivery. Well, thank you very much. You have delivered it very good. You have kept up the time frame. And also the buyer does some act inconsistent with the contract. That is, he sells the goods, he converts the goods into some other shape, and he makes money over it, but does not return the goods or does not resign the contract within a reasonable time. Then in that case, it is said property has already passed on to the buyer. Buyer cannot go back as far as the purchase is concerned. Is it clear to you, please? Buyer is deemed to accept. So he cannot. So I told you also, once the acceptance reaches the offerer, it completes the contract. You cannot retract from the contract. So long as the acceptance does not reach the offerer, the contract is wide open. But once acceptance is communicated by the buyer to the seller receives the acceptance, you cannot take it back. But there is one mode of taking it back. That is, within reasonable time, before it reaches the seller, you repudiate the contract and hand over the goods to him. Then in that case, you have not accepted it. So offer and acceptance completes an agreement, and that agreement, which is enforceable in a court of law, is what is called a contract. So the question is, once the buyer intimates the seller, I've taken delivery of the goods, sir, thank you very much. Then he retains the goods, does certain acts which is inconsistent with the ownership of the seller, sells the goods, converts the goods for himself, and then makes money over it. He cannot go back on the contract because he has not resigned the contract or avoided the contract within reasonable time. This is what section 35 is concerned. So once acceptance is communicated, and the buyer does certain things which are inconsistent with the contract, sells them in the market, it is deemed that the contract is complete. This is what 35 says, sir. 36 says whether it is for the buyer to take possession of the goods or not, for the seller to send them is a question depending on each case on the contract express or implied. Whether it is for the buyer to take possession of the goods or for the seller to send them in is a question. Each case depends. You cannot have a watertight compartment and say these are the conditions on conditions of sale, conditions of taking possession. Each case has to be decided within the parameters or the facts and circumstances of each case. Whether the seller has to deliver the goods and the buyer has to take delivery of the goods depends on the contract between them. That's why it is said in Hindi, Miyan Bibi Razi hai to kya karega Kazi. That means if both the seller and purchaser agree upon the terms, agree upon the conditions, when the delivery has to be done, when the delivery has to be taken, when it has to be accepted, what is the time within which it is to be accepted, depends on each case on its merits. Then delivery of wrong quantity, that is section 37. Suppose I order for 10,000 bags of rice, then it is said the buyer shall reject the goods, but if the buyer accepts the goods, he shall pay for them at the contract rate. So suppose, let us say, suppose wrong quantity is sent. Instead of 10,000 bags, he only sends 3,000 bags. But the buyer does not repudiate the contract, does not avoid the contract, utilizes the goods for his benefit, sells the goods in the market, makes money over the sold goods. Then in that case, repudiation is not available to the purchaser as far as section 37 is concerned. And whatever he has purchased at the contract rate, he is bound to pay for that to the extent of the quantity received by him. Then 38. 38 deals with when there is a, that's why I said Miyan Bibi Razi hai to kya karega Kazi. That means where the husband and wife agree, there is no question of any disagreement or any, there is nothing like repudiation. Suppose, let us say, both the seller and the purchaser agree upon the terms of the contract, delivery as well as purchase. They reduce it to writing in the form of an invoice, and it is sent, it is accepted, it is considered, so on and so forth, and all the valid conditions are satisfied. Then in that case, it is said buyer is bound to accept. Suppose you agree to accept it in installments, buyer cannot say, no, sir, you have not delivered it in a bulk. I'm going to reject it. You cannot reject it. Once you accept it to receive in installments, you are bound by the contract and bound by the terms and conditions. That's what 38 says. Then 39 is seller dispatching the goods by carrier, whether named or not, for the purpose of transmission to the purchaser or delivery of the goods to a wharfinger for safe custody. Custody is prima facie proof of delivery, and the seller can make a contract with the agent. See, sometimes what happens is the goods are already handed over to the carrier, or goods are kept in a what is called for preservation warehouses, and as a purchaser is intimated, I've kept it for preservation in a warehouse. It is ready for being delivered, but due to certain conditions, it cannot be delivered to you. Please wait for some time. So it is said, dispatching the goods by carrier or by a mercantile agent, whether named or not, or keeping the goods in a deliverable condition in a warehouse or cold storage, as you call it. Sorry, I got that word. Cold storage for preservation. Then the buyer is intimated about it and it will be delivered to you. Don't bother about it. Then it is said it is substantial compliance of the terms of the contract. That's what section 39 says. Section 40 says, at distant places where the seller appears to deliver at a distant place, the buyer shall take the risk of determination. Here it is said, suppose, let us say, the risk where goods are delivered at distant place, where the seller appears, agrees to deliver at a distant, the buyer shall take the risk of determination. Suppose, let us say, don't think that, suppose you are staying in LB Nagar, goods will be delivered to you at LB Nagar. What the goods will come to the godown at, let us say, Secunderabad. Then it is also agreed between the parties. The buyer says, don't bother, sir, put it in a deliverable condition. I'll take delivery of the goods wherever it is, though it's a distant place. Then the buyer cannot go back on the contract and say, I will not take delivery. This is what section 40 says. We'll now start the interaction period, please, because it's raining heavily here. We'll start the question of this. And we have got only about 20 sections to be completed, sir. After this, I'll go to the Partnership Act. And I think some lady yesterday, I think it was Nokia, who asked for drafting and the rules of pleadings and so on and so forth. That I will take after completing the commercial subjects, please. Now the question hour starts, please. Any questions, please? Kalyander. Now we start the question hour. Any questions, please? Nokia has not arrived today. Mr. Swami is also there. Mr. Kirtan. Mr. Kirtan. Shruti Kirtan from Tirupati. Any questions, sir?
Sir, good evening, sir.
Good evening.
Sir.
Swarna from Vizag.
Yes, sir.
Yes.
Good evening, sir. How are
Good
you,
evening.
sir?
Fine, thank you.
And my doubt is yesterday only I used to ask, but other talks in between we didn't speak to. But now one agreement was executed in between, unregistered agreement in between two friends as a business agreement.
Yes.
Last 20 years back.
Yes.
Since then, they were continuing that according to that agreement only their
Yes.
business.
Yes.
And now recently they got disturbances, disputes, and the agreement was the 100 rupees stamp paper they executed.
Yes.
At that time.
Yes.
So now that is in force or not?
See, madam, just I will please clarify whether it's regarding immobile property or it's regarding movable property, or it is regarding.
It's a partnership deed, like sir.
Partnership deed. It's an agreement between the parties. It's in the form of an MOU, isn't it?
Yeah.
If it's an MOU, 20 years back, MOU was not in existence at all. It's a mutual agreement. The amendment which had come was in 2001. 17B was introduced in the Registration Act. It says if it concerns immobile property, it has to be registered and a proper stamp. But what you say is 20 years back. Whatever 20 years the transactions had gone through, which has not been decided till now, the disputes have to be resolved amongst themselves. The question of agreement working itself out does not arise.
Okay. So that according to that agreement,
terms and conditions.
Yes, terms and conditions. There will not be any.
No.
Legal thing to go, sir. To go to the court and approach the court.
So, you just watch out if there is any clause for arbitration in that.
Nothing, sir.
If it is not there, you can definitely go. Go in case you have got any grievance.
Okay.
It is clear.
And one more thing.
Yes.
Sir.
Yes, madam.
And another thing is, sir, one will has been written by a father.
Yeah.
And his number of properties were there.
Yes.
He is after that will was executed in the year 2021.
Right.
So sorry, 2001.
Yeah.
2001. That means 23 years back.
Which
then later on into
which part, madam? Where?
Srikakulam, sir.
Srikakulam. Okay, right.
And later in 2004 he expired.
Right.
According to that will, he has stated that he has given all the gold and ornaments and some properties to the girls of 7
పెద్ద ఫ్యామిలీ ఉంది
చాలా పెద్దది
కానీ క్లాస్ రాలేదు డాటర్స్ ఇలాగే క్లాస్ రాలేదు
సార్ డాటర్స్ 7 అబ్బాయిలు 5
అదే అంటున్నామా కాస్ ఫర్ ఫిక్షన్ ఇస్ ఓన్లీ దిస్ గోల్డ్ అండ్ సో కాల్ గోల్డ్ పాడుగాను దాంట్లో కోడలకు కూతులకు కయ్యాలు అవుతుంది
అదైతే గోల్డ్ విషయంలో కోడలకి ఎవరికి రాలేదు కానీ ఇప్పుడు ఈ ప్రాపర్టీస్ ఏవైతే హౌస్ గానీ చిన్న బిజినెస్ గానీ ఉందో ఆ కొడుకులకి ఇచ్చేసారు.
రైట్.
అమ్మాయిలందరికీ పెళ్లిళ్ళు చేశారు. దే ఆర్ వెల్ సెటిల్డ్ నౌ. దే ఆర్ అవుట్ ఆఫ్ ద కంట్రీ. సమ్ ఆఫ్ దెమ్ సెటిల్డ్ వెరీ వెల్ అండ్ ఎవ్రీబడి టోటల్లీ సెటిల్డ్ వెరీ వెల్. అండ్ నౌ ఆఫ్టర్ 2005 Succession Act amendment, now recently those ladies, everybody, all the 7 gave a notice and they filed a case
for partition,
equal partition among all this.
Right. In this regard, madam, I would like you to refer to 2020 Supreme Court, Vinita Sharma versus, I think, in that the question arose whether the amendment is retrospective or prospective. But the Supreme Court of India held that the right of a female child is both retrospective as well as prospective. The question of her marriage or otherwise does not arise. Vinita Sharma, I think if I'm correct, Vinita Sharma or someone else. The question is, they said, as soon as a girl child is born, she gets equal rights in respect of her co-personal ancestral property also. Self-acquired, there's no problem because self-acquired, she's a class 1 here as far as Section 6 and Section 8 of the Succession Act is concerned. The real problem had come, we had 2 acts, madam, 2 amendments, if you remember, during N.T. Ramarav's time, Section 8A was introduced, whereby they said all girls married after 28 February 1985, they get equal rights in respect of ancestral properties also. But the central amendment which had come in 2005 said that a girl child, as soon as it is born, the right which she gets is a vested right and she shares equally with the brothers. That's the reason when that amendment came, I wrote an article saying that the Pandora's box of dowry deaths have been opened. Please remember, I could tell you with experience that the sons-in-law only come to me, daughters don't come. Daughters are not, well, మా తండ్రి గారండి మంచిగా పెళ్ళంతా చేశారు గోల్డ్ అంతా అది మీ తండ్రి గారు ఇచ్చి ఉంటారు నాకేమి ఇచ్చాడండి ముస్తి అని సో వాడు ఇన్స్టిగేట్ చేస్తాడు డాటర్ because unfortunately what happens is even though lady who's sitting here, I do not know her name, Advocate Swarna, the question is the girls are always in the grip of their husbands. That is why it is said but it is the other way around now. The girls are in a dominating position compared to the boys. Because the question
in this case, sir, all the properties are self-acquired by the father.
Self-acquired unna kudama. The question is, as far as the girl child is concerned, she gets equal rights under Section 8. Your dispute is regarding ancestral property. Ancestral property, no, your dispute is self-acquired property. Also, she gets a share, provided there is no partition deed or no decree for partition giving it to the sons.
So will is registered, sir.
Even the will is registered. The question of they get a right, madam. That's what. That's how your ladies are benefited.
Okay.
Vinita Sharma's case. Vinita Sharma's case, you kindly go through it. That is 2020 Supreme Court, where they said the act is retrospective as well as prospective.
Okay. Now the states has to be divided by all the
equally.
What will be the status of the will, sir, now?
Status of the will, no doubt, will be put. But the question is, the boys will naturally take up a defense. We పెళ్లిళ్ళంతా చేసాము ఏమేమి ఇచ్చేది ఉందో అన్ని ఇచ్చేసాము మాకు ఇంకా ఇచ్చేది లేదని. But that will not stand today because of the Vinita Sharma's case.
So now the loans, anything, debts are there?
Debts means all of them will have to share. అంటే అసెట్స్ నేను తీసుకుంటాను కానీ పిప్పి నాకు వద్దంటారు. ఆ జ్యూస్ నేను తాగుతాను కానీ పిప్పి నాకు వద్దంటారు అమ్మాయిలు కదా అల్లుళ్ళు.
So now we have to suggest them that it should be partitioned equally among
exactly. Or take a
and one part should be given to the wife, sir. Wife is still alive.
She gets the remainder, madam. She also gets a share. She is also class 1 here.
Yes, okay.
But one thing I came across a case, your interesting case, like what you have suggested. The dispute was between the mother-in-law and the daughter-in-law. The daughter-in-law, the son was employed in State Bank of India as a clerk or an officer, whatever it is. The son died in service. Then what happened was the SBI gave the job to the girl, that is the daughter-in-law, on humanitarian grounds. The bank did not stop with that. What the bank did was all the terminal benefits also was given to the daughter, the girl. That is the widow of the deceased. The mother filed a suit saying, sir, I am also a class 1 here under Section 8 of the Succession Act. I also should get a share. The bank has wrongly paid the money. Bank should pay me my share. But unfortunately, I was the advocate for the bank. I got, because Provident Fund rules of the State Bank of India is something unique. I didn't have that book with me. I called for that book from Calcutta. In that, there is a clause to say a person acquires everything by birth, but he acquires his wife or children only after getting married or so. Even if the nomination is in the name of the mother, it gets automatically wiped out when a person acquires a family. So the question of nomination does not play. So they defined the dependents as spouse and children. The mother was excluded. It's a special enactment of State Bank of India. You can check it up also.
Okay. But mother is also one of the...
Maybe, but under general law, but nomination is in the name of the daughter-in-law.
He gave his nomination in the...
When he gave the nomination, he gave the nomination in the name of his name of his mother before getting married. But after marriage,
it is...
Talla Pellama antaru chudandi. But and that girl got married again.
Oh my God. So mother only lost it.
Mother lost. I conducted a case up to the Supreme Court. But unfortunately, we are paid by the bank. We have to defend the bank. I know myself that consciously it is wrong. But still, there is morality and legality are something different, madam. Morally, you may be wrong. Legally, I am correct. ఇప్పుడు ఒకటి మీ ఆంధ్ర ఏరియాస్లో కాణిపాకం అని ఒక ప్లేస్ ఉంది. I think Chittoor district. There I was told, suppose let us say you borrow some money from me, you execute a promissory note. You say, sir, I do not know this person, I have not borrowed the money and all, I am not liable. Then both of them go before the God, that is Lord Vinayaka, and then take a oath. Then as a person who has lent money, I say, I have lent the money. That fellow says, no, I have not received anything. They say, take oath before God. And if you say that you have not received it, I will tear the promissory note here itself. But still that moral force is there. They get scared of that God. They say they don't speak lies. And there's one other place, madam, in our south. There is in Salem, actually, Tamil Nadu. There is one place called Kolli Hills. In that Kolli Hills, what happens is there is no theft, there is no robbery, there is no illegal acts also. But they say if anyone indulges in that, he will not come down. He will die there on the way itself.
Oh.
So another place is there, Dharmasthala in South Canara. Yeah, if you go there for a pilgrimage, Manjunatha Swami temple, there what happens is your luggage will not be taken care of by anyone. You just throw the luggage on the road. No one will touch it also. Even if your purse is found on the road, no one will touch it. And suppose you lose money, the trust people say, sir, how much you want? 5,000 rupees. They take your address, Aadhaar card details and all. Please go home and then return the money. Then immediate morality is, I return the money. Please remember, these inka punyalanni inka undama. Because that's why we are living.
Yes.
Of course, morality and legality is something different. And legality ఎవరు నేర్పిస్తారంటే మీలాగా నాలాగా వకీలే చెప్తారు. ఇట్లా అందుకే అంటారు ఇది న్యాయవాదులు పాపాల భైరవులు అంటారు. అందుకే అంటే we suffer from what is called guilt complex. 90% if you go to Tirumala, you find advocates, doctors, architects, contractors and all, because we suffer from guilt complex. అంటే పాత పాపాలు వదిలేసి కొత్త పాపాలు చేస్తామంట. అదే తిరుపతికి పోతే అదే మనమే కనపడతాం. And auditors normally go in the March end when the accounts are submitted and income tax పంపించాడు. ఎనివే ఇంత ఫడ్జీ చేస్తాడు కాబట్టి.
Exactly, sir.
That's why I say our profession, though we are continuing, it's not a righteous profession.
Yes, sir.
Our conscience takes us somewhere or the other. Conscience చూసుకుంటే మనం సంపాదించలేము.
అంతే సార్.
కాన్షియన్స్ అమ్ముకోవాలి. అందుకే కృష్ణ అంటాడు కదా కర్మ థియరీలో, డూ యువర్ డ్యూటీ కరెక్ట్లీ. డూ ఇట్ ఈవెన్ ఇఫ్ యూ హ్యావ్ టు స్పీక్ ఫాల్స్హుడ్, స్పీక్ ఇట్ బోల్డ్లీ. సేవ్ యువర్ క్లయింట్స్.
So now my client will be losing, I think.
Definitely, because the Vinita Sharma's case is clinching.
Yes, sir.
Just go through that case, 2020 Supreme Court.
Yes, sir. Thank you, sir. Thank you.
Any more questions?
Sir, good evening, sir.
Good evening.
Sir, this is Krishna from Isaac, sir.
Yes, sir, please.
Sir, buyer and seller entered in an agreement and along with MOU regarding the immovable property, sir.
Right.
What kind of rights they have and what is the limitation for this agreement?
First and foremost is, what is the year of agreement, sir?
Sir, this is more than 3 years, sir.
More than that is after 2001.
Yes, sir.
After 2001 means 17B, it has to be in writing and it has to be duly registered.
Okay, sir.
The compulsory. Yes. Or under section 49, it can be looked for a collateral purpose, though not for the primary purpose.
Okay, sir.
Yeah.
Got it. Thank you.
Or you can get it validated also.
Okay, sir.
Yeah.
Any more questions?
Nathan, sir.
Yes, please go ahead.
Sir, actually, when partition deed, the power of attorney, once it is registered, why for cancellation again also it has
It
to
should be
once
by,
a
it should be,
year.
it should be again by a registered instrument.
So even cancellation should be again registered, sir.
Registered instrument, and both the parties will have to be present. It's a bilateral document.
No, because it's a grandfather's property.
Yeah.
One of my office colleague was asking this doubt.
Right, sir.
So grandfather's property that among sisters they are dividing it.
Right.
The other sister is in USA now. She has given a power of attorney.
She can give, sir, but it has to be validated. Once it reaches the shores of India, it has to be validated by the secretary, in the secretariat, sir.
Okay,
It should be
has to be validated.
authenticated, rather.
Authenticated. It cannot be. The power of attorney it has to be cancelled. Can it be done by authorizing someone here, sir?
No, sir, it can't be done, sir. Only that person who has given the power of attorney should cancel it.
It can't be done.
No, sir.
Okay. Suppose if he is staying in a foreign country, what is the position, sir?
Then the cancellation will have to be done in that particular country where it is executed. And public notice also has to be given.
But the property is situated in Chennai, sir.
Even if it's situated at Chennai, sir, the question is cancellation has to be done at the place where the document is executed, and also a public notice given intimating the public, sir.
But document was executed here only.
If it is executed here, cancel, but she has to come here to cancel the document. And or she can come here, and but subdelegation cannot be. But she is the principal, is it, who has executed the power of attorney?
Yeah, power of attorney has been executed by her.
But if she has executed, she can authorize anyone to cancel it and present the documents for registration.
Okay, sir. Thank you, sir.
Welcome.
Thank you very much.
Any more questions?
Sir, one doubt, sir.
Sir, good evening, sir. I have one doubt, sir.
Just a minute, Swarna.
Sir, adverse position will be with the
Possessor,
sons, no, sir.
with the possessor for 12 years.
Yeah, 12 years.
Yeah.
So from 23 years since with the father only, they continued the business, joint business, and that joint properties also. Later on, he gave the will. In the will, he specifically noted that this son has to get this one has to get that, and the business also jointly. My two sons has to take care of the other two sons took care of another business, like that. He specifically gave, and they are in possession since 24 years.
They can protect. Tell me. Go ahead.
And all the municipal tax, everything were mutated, sir. And I think they will be having adverse possession also.
Exactly. You'll have to plead saying that the partition has already taken place, the division has already taken place, the property has already been distributed. 23 years, no one has questioned it. Now it is not possible for anyone to question it, because even if it's a will, after the demise of the individual, it has come into force. The question of challenging it does not arise.
Okay.
Yeah.
Okay. Then there is a life for this case, sir?
Exactly, madam. Exactly, madam. But it has to be specifically pleaded.
Right. Okay. Thank you very much.
Well, somebody asking some question earlier.
Yes, sir. Next.
Sir, good evening, sir.
Good evening,
Mr. Das.
Yes, Mr. Das.
Sir, I have one doubt, sir. I filed under Indian Succession Act partition suit, sir.
Yeah.
Hello?
Yes, sir. Please go ahead.
Am I audible, sir?
Yeah, you're audible, sir. Please go ahead.
Mother died in intestate, sir, leaving behind sons and daughters, sir.
Yeah.
What is the legal provision, sir, under Indian Succession Act?
Sir, what are the parties that are Hindus or Christians, sir?
Christians, sir.
If they are Christians, Indian Succession Act applies. I think if I'm correct, it's 36 and 37 of the Indian Succession Act. When any person dies intestate, the property has to be divided equally.
Equally, but he's where it is mentioned legal provision, he's asking, judge is asking
36 and 37. So 36 and 37 of the Indian Succession Act, it has to be divided equally.
36 and 37, sir.
Of the Indian Succession Act.
Okay, sir. Thank you, sir. Thank you very much.
Any more questions?
Yeah, one second. Sir, good evening. This is Anuradha.
Yesterday you were not there, madam.
Yes, sir. I missed it. I was not home.
Yes, yes, madam.
I missed your precious lecture yesterday.
One of your relation is a district judge, isn't it, madam?
Yes, sir.
I think Srinivas Bakkaraj.
Yes, sir. He's Srinivas Rao Bakaraju.
Yeah. And
He's my first cousin's son.
yeah, right, very good. Where are you practicing?
I'm at High Court, sir.
High Court. Yes,
CRP and High Court.
yes, carry on, madam.
Sir, as per Section 34, there was a agreement to deliver the goods in part. So first and the buyer had paid the total sum, and first and second parts were delivered accordingly. And in the third, there was a delay, and there was also faulty delivery of goods.
Right.
So what is the remedy available to the
He has
buyer?
received even after delay.
Yes, sir.
If he has received
delay
it,
and faulty goods.
yeah, even if he had received it after delay, the question of repudiation does not come. He can only ask for damages for the belated delivery and the defects or whatever it is in the goods.
Okay.
But you have to first issue a notice first.
Okay.
Right.
Okay, sir. Thank you.
Thank you. Anybody else, or can we wind up the case today? Nagachandram.
Nagachandram.
కాంట్రాక్ట్ అగ్రిమెంట్ లో
చెప్పండి.
హౌ మెనీ డేస్, ఎన్ని రోజులు లిమిటేషన్?
Limitation ఏం లేదండి. Depends upon the contract between the parties. What the law says is reasonable time. Reasonable time depends on facts and circumstances of each case. And long delays are normally non-suit a person.
వాళ్ళు కావాలని కండిషన్ రాస్తే కూడా కండిషన్
మీరు అప్పుడు ఏం చేయాలో, say that there is a breach of that condition, you have not followed the condition, I am repudiating the contract, no notice even see what defense that fellow takes.
సిస్టర్ రిప్లై చేయలేదు. స్పెసిఫిక్ పర్ఫార్మెన్స్
Specific performance, sometimes you have abnormal delay disentitles a person for specific performance. And I think if I'm correct, actually, sir, to be frank, unless the delay is made the essence of the contract, question of specific performance cannot be disallowed, sir. Only thing is, suppose abnormal delay is there, it may be one of the reasons why specific performance will not be granted, sir. Only return of the money, whatever it is. Am I making myself clear, Mr. Nagachandran? Yes. Next, Andy.
All right, we are winding up as of today. Thank you. Thanks for your time. We'll see you tomorrow again. Bye-bye.
Madam, pen ఇస్తారమ్మా? వరలక్ష్మి గారు.